Hello and welcome to today's webinar, Global Investigations and the EU Whistleblower Protection Directive, what U.S. companies need to know. Today we're excited to talk about the new protections and requirements under the upcoming EU Whistleblower Directive, how it will affect U.S. companies as well as global investigations, what are best practices, and how can we apply those to future investigations in a steadily evolving business environment. I'm Marco Goldberg, Managing Director at EQS Group North America, and it is my pleasure to introduce you to my two fellow speakers today, Fred Combe and Keith Millott, both who are with our partner Grant Thornton. As for Fred Combe is a partner at Grant Thornton's Forensic Advisory Service Practice, and in this capacity, he leads large complex investigations, forensic accounting services, and corporate compliance engagements in various industries for public, private and nonprofit organizations, and Fred has over 25 years of experience in the field across various industries. Fred, it's a pleasure to have you with us today on this webinar.
Thank you, Marco. Yeah, we're looking forward to presenting with you today, and given this interesting topic and some new regulation in the EU, I think the content's fantastic, and I think it's really timely. So thanks so much for having us on the presentation today.
Excellent, thank you. And we also have Keith here with us, Keith Millott. Keith is a manager at Grant Thornton's Forensic Advisory Service Practice, focusing on investigations, forensic accounting, auditing engagements, compliance assessments, litigations, really a broad scope. And Keith has managed investigations for clients in various sectors and is very experienced in identifying red flags and pursuing them to discover fraudulent activities. Keith, I'm excited to have you with us here today.
Thanks, Marco. Appreciate the opportunity to be here. Aside from the important regulatory topics we're going to discuss, it's a pleasure to speak to everyone today about my experiences and perspectives on whistleblowers and investigations. So happy to be here.
Fantastic. Great. So before we really get into the topics of today, I just want to give a quick explanation about the most important functions here on our webinar platform. And at the bottom of your screen, you will see some icons that allow you to show and hide the most important modules. If you need any help with the system, please just click on the question mark and submit a brief description. We'll try to support you there. And on the camera icon, you can also show or hide the streaming window. Any window really can be dragged and dropped back and forth. You can change sizes to the desired positions. And most importantly, I would like to encourage everyone, all of you, to please use the speech bubble with the question mark to send in your questions at any time during our session here today, during our webinar, and we'll make sure to address these questions at the end during our Q&A session. And for a high-level agenda, we will start off our webinar today with the topic of the EU Whistleblower Directive and then transition over to global investigations, which Fred and Keith will take over at this time. But now I have the pleasure to get us on the way with our first topic, the EU Whistleblower Directive and how it will affect U.S. companies with global operations. To start off, there has been now a 2-year transposition phase from the EU Council, from the EU Parliament, allowing all the 27 member states to transpose the directive, which was issued in 2019. And we are just about a month away on December 17th when that deadline expires. So it is a very timely topic for organizations who have global subsidiaries to consider the new regulations. And before we really get into all the requirements, all the key facts, I want to take a quick temperature check here of everyone on the webinar with the first poll question. And the question goes, at your current company, do you have a global confidential reporting system in place which also covers locations in Europe? And it would be fantastic if you could check the appropriate answer that reflects your situations, we have yes, we have a global speak-up line in place offering local language reporting. Yes, we have a speak-up line in place offering EU employees to report in English, or no, we don't have a global or local system in place at the moment. So we're going to give everyone a little bit of time to submit your answers here. Okay, let's take a look at the results. Interesting. Looking at the results, yes, as it kind of expected, we have around 70% of participants on today's webinar who have a global speak-up line in place, and a smaller percentage of which are reporting only in English. And then, of course, it's also interesting to see that there are still 30% who are looking to possibly implement something as a result of the new directive. So that is good to keep in mind. And with that, I will jump into the key facts of the EU Whistleblower Directive. And we have a nice summary here of the key facts and the scope, ultimately starting with what, right? So 2 years ago, the EU Parliament and the Council issued the directive for really the protection of persons reporting infringements of EU union law. And the directive is targeted to protect the reporters from any sort of retaliation and offer also protections across a now extended number of channels to make reports outside of just the internal channels, which had been covered by various legislations globally. Now European citizens or anyone in the European Union will also be covered reporting externally, so through authorities, that will be protected, as well as the public if there is an imminent threat to the public. On the question of who will be affected by the new directive, it will be any organization, any company, public or private, with more than 50 employees, or municipalities with more than 10,000 inhabitants. And important to note is that with companies within industries where the risk of money laundering or terrorist financing is existing, examples are car sales, currency exchange, real estate sales, it won't matter the size of an organization. Any company will have to comply with the new EU Whistleblower Directive. And the final point here on this slide, when we know that it's coming into effect in December 17th, and it will start with any organization over 250 employees. And then there's a 2-year phase where companies between 50 and 250 have time to implement the necessary measures to comply. And then as of December 2023 is when also companies with 50 plus employees will have to comply. And one thing that is quite important to understand, that because of the nature of a directive, there may very well be 27 different variances of the local transpositions of the directive into local law, because the directive is designed to be a minimum requirement, and countries can decide to implement even more stringent protections, certainly not more loose. So that is an important thing to note. For example, the Czech Republic has already reduced their guidance around the thresholds to 25 for the year 2023. Any company with more than 25 employees will be affected, and people and any stakeholders will be protected. Moving along, who will be protected? So the protection is extended to a very wide range of people outside of current, former employees. It also includes vendors, also so-called facilitators, so vendors, suppliers, or even joiners. That means applicants are covered by the directive. instances or issues like nepotism. The EU is looking to combat with this. So it is now a very wide range of individuals, and it doesn't necessarily only have to be employees. It could be their spouses, vendors, contractors, trainees. So it's important to keep in mind this new directive protects a larger range. And the next question, how will they be protected? One of the most important aspects is the protection from retaliation. So the EU Commission, the European Parliament, really wants to ensure that reporters are protected from any retaliatory measures. That includes dismissal, demotion, suspension, intimidation, or reassignment within an organization. And an example could be, of course, an employee reports an issue. The issue never really is investigated properly, but the employee is reassigned to a different department. These are things that the European Union wants to prevent, or third parties, right? A third party vendor could be reporting an incident, and then the next year, the contract is no longer extended. These are the types of retaliatory actions that should be prevented with the directive. One very interesting aspect of the directive is, and it's quite unique, is the reverse burden of proof. So in the past, the burden of proof was always with reporters who had to submit proof about any retaliatory measures that were taken against them. Now, this burden is falling onto the organization. So that, of course, changes quite a bit in the way that we have to review what happens after a report is issued, what are the outcomes here. And an important thing to note is about 33% of employees, following a study by the Global Ethics Organization, say that they will not report misconduct because of the fear of retaliation. So fear of retaliation is really a major aspect here. There are some other protections, however. We have the exemption from liability for how to acquire and accessing information that's reported. We also have the protection of the identity, which of course goes hand in hand with retaliation, as well as access to appropriate remedial action. If there are legal proceedings, reporters may be eligible to receive interim relief. The final question here is, what can be reported? To sum it up, it's a very broad range of infringements of EU law. At a very minimum, it includes protections of privacy of personal data. We have EU competition law, touched on money laundering, terrorist financing, public health. Not to read all of them, but ultimately it's a very wide range, and it's assumed that all of the 27 member states will also cast that net very widely. So that is something to keep in mind. And moving along, one interesting aspect of the directive is in regards to the channels which whistleblowers can use to report misconduct. So an essential aspect of the directive is the duty to inform about reporting options, internally, but also externally. So the protection will cover, the directive will cover reporters who report internally, of course, confidential. There are certain rules that we'll look at in a second. It will also cover reporters who report externally, so to authorities, as well as the public, in case there is an imminent danger to the public or there is a significant risk of retaliation. Also, it's notable that there's no requirement in terms of the order that a reporter has to follow. He or she can decide whether they want to report internally or report externally or even to the public, and there is no prescribed order in the regulation. And so because of that, it is obviously important that you have a functioning and also effective internal channel where there's awareness within your stakeholders, employees, third parties about the existence of that internal channel, because otherwise, as we all know, there is financial and reputational risk if reports are made outside even to the public. One important thing to note is that when we look at the requirements, there is the duty to inform about reporting options. And ultimately, what companies will have to do is to provide the contact points for the regulators per country. Each country has obviously a different regulator, and it will be important for companies to provide that information to any stakeholders. Let's take a look at the status of where we stand in terms of the local transposition. At the moment, only Denmark and Sweden have successfully fully transposed the directive into local law. The current progress, it looks like about 44% will have it transposed. 44% of member states will have it transposed by the deadline, December 17th. And it already shows that about 81% of member states have at least started the process of transposing the directive. So realistically, it looks quite promising that all of the 27 member states will have it transposed by the second quarter at the latest of next year. Now, let's take a look at the requirements of the EU Whistleblower Directive in detail. Going from left to right, the first requirement here is the duty to offer internal channels, which include internal reporting channels, which include online, phone reporting, also voice messaging, as well as a physical complaint box. What's interesting is that companies will also be advised to offer physical meetings to reporters, which of course creates certain difficulties around the protection of the identities, which brings me to the next point. There is an absolute duty to keep the identity of reporters confidential, ensure anonymity, because that is really the only way to prevent retaliation. So this is a key aspect of the directive here. Companies are required to appoint an impartial person or team that could be internally or externally, consultants, advisors, an impartial team to conduct these investigations. That is important. One of the to be expected requirements, of course, are GDPR compliance. Personal data will have to be processed in accordance with GDPR, but it's also important that the reporting channel must be protected and secure. So from a data processing, data security standpoint, that will be important. A very new requirement under the directive are deadlines for providing feedback to whistleblowers. So we have under the directive up to 7 days to provide the initial acknowledgement to reporters, and then up to 3 months to provide a status update on the outcome of the investigation. We have to do this within 3 months going forward. The next one here is the duty to inform stakeholders about the reporting options. And this has to be easy to find, easily accessible to any stakeholders of the business. And it kind of goes hand in hand with the last requirement here under the EU Whistleblower Directive, the duty to disclose reporting channels, external reporting channels, so supervisory authorities. Companies must provide information on alternative reporting channels, so per country, really to provide the information about the regulator, how they could be contacted in case a reporter decides to choose that channel. And so now that we have looked at all the new requirements, I want to touch on why is this relevant, right? How are US companies affected by these new requirements? What's the relevance here? And the most important aspects are really that US companies with more than 250 employees in any of the 27 European member states will be subject to the new laws. And it's important to note again, these transpositions will vary. We're obviously closely monitoring this, and we'll also issue additional updates on our compliance knowledge hub on this topic. But what does that mean? So that means that companies should really implement internal reporting channels. They should protect the identity of the reporter. They have to take the necessary steps to prevent retaliation. That goes hand in hand with the reverse burden of proof, being able to have an audit trail and being able to show that there was no retaliation on reports will become very important. The duty of information, fulfill the duty, of course, to disclose the reporting options internally as well as externally, and meet these feedback deadlines, the 7 days, the 3 months. Otherwise, there are sanctions. There will, of course, be reputational damage if companies fail to provide the protections under the directive. In terms of penalties, there will be penalties for obstructing the reporting of concerns, allowing retaliatory measures, failing to protect the identity, and it will be up to the member states, up to the national legislators to determine the severity of those sanctions. That's important to note. And now that we've looked at all the requirements, I want to take another quick temperature check here of the audience, of all of you. The question, our second poll question is your existing confidential reporting program equipped to comply with the new requirements of the directive? Possible answer is yes, we are prepared to comply now that we have heard the requirements again partially. We still have to revise our reporting system and policies to make sure we will fulfill the requirements, or no, at the moment we are not yet prepared to comply here. So we will give all of you a couple of seconds to submit the respective answer. And we'll take a look at the results now. I see we have about half submitted. So yes, as anticipated, with a lot of companies, a lot of you having global system in place, you are very likely already partially complying with the new regulations. A good number feel they're very comfortable, and a smaller number are not yet prepared. Obviously, we are very happy to help with this. And of course, please, at this point, feel free to submit any questions as well of topics that we haven't touched on. So just as a quick summary, what are considerations to become compliant in case you're partially compliant or not compliant yet? It will be important to install mechanisms to ensure anonymity, right? Ensure anonymous reporting, prevent retaliation, have that in your policies to be able to show that the organization does not tolerate retaliation. Keep these processing times, establish internal procedures, and fulfill the duty of information for those countries that you are operating in. It is recommended to, where possible from a resource perspective, train and install local compliance resources to at least review reports. One of the spirits of the directive is to take away anything that can obstruct the reporting of concerns, and with the fear of retaliation, if a report is reviewed maybe in another continent where the company is headquartered, like the US, from a European perspective, that may deter people from making a report. It is recommended, not required. Full transparency, there's no requirement to implement local reporting channels at a subsidiary level, but for organizations with more than 250 employees, it is certainly recommended to consider installing a local solution with local resources reviewing. From an investigation standpoint, of course, there can be support from other regions there. And ultimately, the last point is revising policies to reflect the new requirements, the information duty of information, the processing times, and ultimately to establish consistent standards across the organization, ideally to, of course, as always, we always try to foster a speak-up culture, protect our employees, but also third parties, and minimize risk for our organizations. So that brings me to the end of our presentation on the EU Whistleblower Directive. Again, if you have any questions, please feel free to use the Q&A module here on the platform. We'll be excited to address those at the end during our Q&A session. And I see we already have a number of good questions here, but without further ado, I will now pass it over to Fred and Keith here to continue with the topic of global investigations.
All right. Thank you, Marco. And before, maybe we advance the slide, I'd like to first provide, some perspectives on what we're seeing from a global investigative standpoint, and maybe even touch a little bit on the importance of whistleblower hotlines. At Grant Thornton, we've got, I think we're 900 professionals strong across the globe within our forensic practice. And, we kind of work as a cohesive unit. And, when this type of regulation comes into play, and we love to partner with Marco and others to talk about this type of thing, because it's so important for our clients' compliance programs. Before the pandemic, one of the things that we saw from an investigative standpoint was a real mix of where our engagements came from, where the underlying allegations were coming from at our clients. And they came from a variety of sources. And I think if you look at the ACFE or AICPA or other thought leadership, you'll see through surveys that a lot of times allegations, they'd come through, say, a finance function or internal audit, or even, external inquiries from vendors. And also, anonymous whistleblower hotlines. But since the pandemic, I can say, at least from my perspective, a larger amount of our engagement with clients, with some of our larger investigations, have come, really directly through whistleblower hotlines. And so, I think the first point I'd like to make is that, regardless of the size of your organization, the need for a whistleblower hotline has grown. I think it's vital to any, effective compliance program, and particularly if you have a global reach. It's an important part of your compliance programs in other countries, because of differences in culture, people might not be as willing to come forward. And so, again, it's great that the EU directive is now, will be in place soon. Second, I'd argue that, because of, the current remote workplace environment, where, many times employees, they're just not interacting with each other personally, in the office anymore, additional avenues for reporting suspicious activity are really more important now. And again, that's regardless of the size of your organization. Many times, our larger clients, they all have whistleblower hotlines in place. In other instances, sometimes, whether it be private equity or organizations that perhaps are more decentralized, they don't have that central function. And without that central function, they may be missing suspicious activity that otherwise would have been reported if that, whistleblower hotline was there. And so I'd say, the EU directive, in many ways, it really embraces and acknowledges the additional risk that we're seeing from COVID. And, of course, this remote work environment, which, the pandemic has created. But, as we all get through this, in many ways, I think for many companies, we're going to continue to see people working remotely. And that really brings new risk to, all of our organizations. And so maybe with that, I'm going to hand it off to Keith Malott. If Keith is still on, I'm not sure if Keith is still on.
Yep, I'm here, Fred.
Great. All right, Keith, why don't you jump in, take a few slides, and I will mute for now.
Thanks, Fred. So to begin, Marco provided some detail about the upcoming directive applicable in Europe. And given that some of our audience here today is based in the U.S. or at least works for companies with U.S.-based operations, I wanted to cover at a high level a couple of the more important whistleblower regulations that apply in the U.S. So the first regulation we'll discuss is the False Claims Act, which is the first whistleblower law that was passed in the United States. It was passed in 1863, so quite some time ago during Abraham Lincoln's presidency. And the quid tam provision of this act made it possible for any citizen to file a lawsuit on behalf of the U.S. government. So these lawsuits would be filed in situations where an individual knew of a wrongdoing against the government, but something that the government obviously was not aware of themselves. And a key component of this provision here is that the individuals who filed the lawsuits were also made eligible to receive 15 to 30% of the proceeds ultimately collected if there was a favorable verdict for the government. So a bit of a precursor to some of the bounty acts that you see with Dodd-Frank after the Great Recession, which we'll get into in a bit. But with the FCA, it's important to note that it was written to be expansive. So as a result, it's applicable to conduct outside the U.S. as long as there is federal spending, procurement, or contracting activity. The FCA is suitable for building criminal cases as well as civil. And under the FCA, it's possible for anyone to serve as a whistleblower, not only U.S. citizens, but non-U.S. citizens and also non-governmental organizations or NGOs. So fast forward to 2010, and we have the Dodd-Frank Act, which was passed in an attempt to address some of the underlying causes of the Great Recession of 08, 09. So the Dodd-Frank Act was a sweeping piece of legislation, created governmental agencies. It really fundamentally reorganized the financial regulatory system. But one of the measures in the act was the creation of 2 whistleblower programs in the SEC and the Commodity Futures Trading Commission. It also enhanced whistleblower provisions under the Foreign Corrupt Practices Act. Dodd-Frank made it so securities, commodities, and foreign bribery whistleblowers are now covered under these enhanced whistleblower provisions, which focus on protecting confidentiality and anonymity. Individuals could file complaints anonymously and still be eligible for rewards. Previously, that was not the case. They had to make their identity known in order to be eligible for that monetary payout. Another change under Dodd-Frank is that whistleblowers outside of the United States were also now eligible for the awards anonymously. So this has had a huge impact, the Dodd-Frank Act. Since the law was put into place, the SEC and CFTC have awarded over $1 billion to whistleblowers. In 2 cases, the individual payout for one whistleblower exceeded $100 million. And then there are, numerous situations between 10 and 50 million over 20 of those instances as well. So here you can see how some of the regulatory actions in the U.S. have had a big impact on not only protecting whistleblowers, but also making it, frankly, quite lucrative to be a whistleblower in the right circumstances. Okay, so we'll change gears here and talk a bit about our Forensic Advisory Services Group and the types of investigations that we conduct and how we carry them out. So at Grant Thornton, our Forensic Advisory Services Group is frequently engaged by our clients to conduct investigations that start out with a report from a whistleblower. And when we begin an investigation that originates from a whistleblower report, the report itself is the first thing we look at when we are developing our work plan and our scope areas. As you can imagine, the reports come in all shapes and sizes. Sometimes we're provided with reports that include names, dates, and a lot of detailed information about the allegations. In other investigations, though, we've seen reports that are 2 to 3 sentences long, maybe not incredibly logical, the information that's in there. It leaves a lot to guesswork, and the level of detail in the report has a big impact on our scope of work. Aside from the reports themselves, sometimes we are actually given access to the whistleblower for an interview, which allows us to ask specific questions about the allegations. This is definitely a luxury and it's a huge help to our investigative team, but at least in my experience, the opportunity to have an interview with the whistleblower is pretty rare. So we really have to rely on the whistleblower report itself. The vaguer the report, the wider net we have to cast at the start of our investigation. And as we begin our work, our scope becomes narrower as we identify the areas of concern and begin our detailed analysis. But when you get one of those whistleblower reports that's maybe 2 to 3 sentences, not a lot of detail, you really have to look at a wider scope of activities and transactions. But for those situations where we have names, dates, specific activities, vendor names, customer names, that's where we can really kind of go in with a scalpel to start out and have a pretty narrow scope. So In addition to interviews, we also utilize document request lists. So we send these to our clients to obtain documentation and data that we believe will help us uncover facts about the allegations. For example, if we have a whistleblower report related to alleged improper sales activity, we'll request the sales data and also perhaps the expense reports related to sales personnel who may be involved with the alleged activity. Another example, if we have allegations related to maybe a conflict of interest with a vendor, we will request all of the transactions with that vendor and also the documentation related to the procurement process that took place with that vendor. So our interviews, who we select, and also the documentation that we request and analyze is really tailored to each specific investigation. And we're looking for the information that's going to be most relevant to the allegations and help us uncover additional. So I discussed the benefits of having an interview with the whistleblower, but interviews aside from the whistleblower interview are really a core component of our investigative work. And Fred is going to talk about that in a bit more detail.
All right. Thank you, Keith. Yeah, from an interview perspective, again, I mean, the pandemic has kind of created an interesting time. We'll talk a little bit about best practices when selecting interviewees and conducting interviews here. I think conducting interviews and even the selection process has changed a little bit because of the pandemic. When selecting an interviewee, you want to select individuals who can provide additional facts about the allegations, that can help your team gain an understanding of related business processes, whether it be around invoices or approval hierarchies. I like to usually start with the individuals I think that will know the most information about the subject matter, perhaps don't have decision-making responsibility, but may know the details, may have put together the information, may have been, say, the one that was told to do things a certain way, and then build up towards individuals that, actually have the responsibility or oversight of those individuals. When conducting interviews, in today's environment, you want to be strategic about how you frame these questions and what information, you think you'll be able to gain from those questions. I think when conducting interviews today, again, best practice is always to be in person. But if you can't be in person, I think you want to ask the interviewees to be on video if at all possible. I know it's not always, something that's a possibility. For instance, if you're in different time zones, I know that can create issues. Depending on where individuals live, can also create issues, particularly if they are working from home. But you want to see the person's body language. You want to see how they answer questions, how they react to documents. I think, one of the things that has been interesting with the pandemic to me, and I think is going to be best practice moving forward, is that before the pandemic, there were instances where we'd work with outside counsel and we'd go to someone's offices to perform an interview, and the attorneys would have large binders, and they would have printouts of documents and emails, and they would flip through the email and then sort of slide it over in front of someone. And a lot of times it was a difficult way to go through documents. It could be cumbersome because you may want to refer to other documents that perhaps were in other binders. Today, when we perform interviews, particularly when we're remote and we're working online in sort of a Teams or Zooms type format, we're able to more easily share documents. And so when we put together a script, a loose sort of outline of what we want to ask and why, we know where in that question script we're going to provide a document to share, or a calculation. Or ask a question about an email. And so I think in some ways, that's been helpful. And, perhaps moving forward, even when we do interviews in person, we'll use technology in that way, whether we have to bring, larger screens with us or they're available there in the conference room. We conduct the interviews. That's, yet to be told. But, I think it's become, an easier way to share information, to conduct interviews, to ask questions about documentation. And that's been, absolutely fantastic. A lot of times I think you do want to stay away from asking if the interviewee knows who the whistleblower is or if they are the whistleblower. I think you want to respect that anonymity. Oftentimes, the employees that we're interviewing, they don't even know what the true allegation is. And so, when you're interviewing someone, you want to gather the facts. You kind of want to stay middle of the road. And of course, have the documents available to share if you're asking, specific questions about something that someone may have pulled together. And then, finally, from a report standpoint, an investigations report really should only state the facts. You don't want to share opinions. You don't want to discuss or provide narrative around things that perhaps weren't uncovered during the investigation. So I think good practice is always, within the report, having the ability to tie back specifically to a fact that was uncovered during the work that was performed. And then many times we provide recommendations within the final report. At times, if we're working with outside counsel, depending on who's going to see the final report, that's a question we always ask, whether the recommendation should be included in a final report or if they should be kept outside the report, perhaps say in a memo that, again, would be, protected by privilege and confidentiality, but may not be within the body of that final report because, perhaps the readers, the users of that information don't necessarily need to know how things are going to be remediated. They just really need to know the facts of the investigation, that initial whistleblower allegation all the way through to what was uncovered. And then, perhaps just some final thoughts around, best practice. So whether you're engaging someone, like a Grant Thornton or another outside party, or you're working internally and you have individuals identified, or you have a special investigative unit or an investigations team that works, say with legal or other areas, a couple best practices to keep top of mind. When you start an investigation, you always want to think about privilege and confidentiality. You want to keep that circle, that team small, and really only grow that team if absolutely necessary. I think, it's always important to have outside counsel involved. We always recommend that outside counsel be involved in investigations, or at least internal counsel, to provide privilege and, all the necessary confidentiality around the investigation. And then lastly, I think process and workflow is really important. And so, we've developed over time tools and techniques. I think that each organization that wants to take on investigations on their own internally should, look to work and identify and build those processes as well. And I can tell you that, from my experience with the ACFE, who Grant Thornton partners with, there are some great tools that are available for free on their website. So if you're looking for, ideas or sort of a roadmap on how to build out that process at the point where you get the allegation from your whistleblower tool or system, what to do next, the ACFE is really a great place to go if you're looking for, advice and tools and templates to get you started before you kind of customize your own. And if it's something that you have the resources that you want to do in-house versus kind of going outside to a larger firm. I think we have one more slide on best practices here. A little bit about the use of technology. The use of technology now is instrumental in every one of our investigations. We use technology really from beginning to end. A good example of that is from a sampling perspective. If we're able to get a general ledger extract, if we're able to get large amounts of AP data or AR data or subledgers for those, depending on, of course, what you're looking at. But, an example of, say, looking at payments, you don't have to make the judgmental sample anymore if you have the right technology and the right tools. You can look at 100% of the data and you can make a more informed decision based on data analytics that can be done today. And there are a whole host of tools that can be utilized. So at Grant Thornton, we utilize a number of different tools, both for visualization and from analyzing data. We also use e-discovery tools like Relativity and other tools that are helpful for both storing data and reviewing data and identifying red flags and, sort of parking documents for second and third level reviews. And Keith, I'll hand it back to you for some discussion about the poll questions.
Thanks, Fred. Yeah, so this poll question is, do you have an internal team that fully investigates allegations filed by employees? The options are A, yes, B, no, or C, other, or prefer not to answer. So during my time working in forensics, I've found that not every company is equipped to conduct full investigations into whistleblower reports. Could be for a few reasons. They may not have personnel with the required expertise. Also, it is beneficial to have some independence throughout the investigative process, and the best way to guarantee that independence is to bring in a third party. Pretty commonly, we see that our clients have someone from compliance or legal perform an initial inquiry into the allegations, and then they make an initial determination as to whether or not those allegations warrant a full-blown investigation. And if that's the case, they then reach out to us and we begin our work. Okay. All right, so we will go over to the results. Okay, great. So there's a lot of you who have an internal team that fully investigates allegations. Some said no, and some said other. For those of you that do not have a team that fully investigates, maybe your internal team does conduct that initial inquiry as I described, but it's also possible your team outsources the entire process. Fred is going to continue the presentation by discussing 2 case studies that our forensic team has worked on. Fred?
All right, thanks, Keith. And we want to leave a little bit of time for questions at the end. I think we're about 11 minutes left, and so I'll try and move through these quickly. Our first case study, good example of a company that would be impacted by the EU directive. This was an engagement where we worked with outside counsel with one of our global technology clients. The work was performed in the EMEA region and included professionals from a number of offices at Grant Thornton and our client and outside counsel. It originated with a whistleblower report. It was received by our client, which was alleging that a third-party sales agent engaged by our client had received some preferential treatment from the client via additional discounts to win the contract with the customer. And so this particular client, I think like many clients in technology, they utilize both an internal sales force and an external sales force. And so the external sales force, or that indirect sales team, in order to have sort of a level playing field, there's a mechanism around additional discounts that could be provided in order to win a contract, say over a competing software vendor. In this particular instance, you had a sales team from internally at this tech company and the external team, which was sort of a third party. Again, from a level playing field standpoint, the external party that sold the product had certain responsibility around compliance and ethics. They were really, held to the same compliance and ethics standard as the internal sales team, and the client actually performs audits to make sure that that they're in compliance with that. This particular whistleblower allegation, initially when we were engaged, it was interesting because there was some discussion around whether really the allegation was sort of sour grapes. The allegation came through what was identified as the internal sales force, and that internal sales team lost out on a deal to one of our clients' third-party partners. And there was some discussion around, do we really want to pursue this? Do we really want to spend the money on, bringing in a larger firm, outside counsel, to take a look at this? Because, there are always grumblings about, the sort of competitive landscape between internal and external sales teams for this particular organization. But, they moved forward. They decided to engage Grant Thornton. We talked with outside counsel, and we went through a process that, included understanding the allegations, making document requests, talking to different individuals, reviewing contracts, and really specific calculations around the discounts that were provided. And for this particular case, we did actually find that there were inappropriate discounts provided, that it wasn't a level playing field, that the allegations were actually true. And, it's a good example, I think, of, both a whistleblower hotline working and another way, the triage team, the team that, was taking a look at all of the allegations coming through, the triage team taking the allegations serious, deciding to move forward with it. The reason why they did was because the customer that purchased the product was a quasi-governmental entity. There was some concern around FCPA type issues, whether that additional discount could have been used for, say, illicit payments, some sort of bribe. And so they wanted to make sure they tracked down all of the dollars. And so, kudos to that particular client for moving forward and performing that audit. And, we were able to, starting from the allegation in that whistleblower hotline to the end report, document all of the different issues that we identified. The second case study, and we'll just spend a few minutes on this and jump into a few questions, is in the life sciences space. And again, this was work that was performed in the EMEA region, included outside counsel. And in this case, there were actually several whistleblower reports with numerous similar allegations. The allegations were actually made over a period of time. And because the allegations were involving some things like expense reporting, they weren't initially taken seriously. There were some allegations around sales representatives exhibiting improper behavior to induce clients to purchase products. For that reason, I think the risk level increased. The triage team at that particular client decided to move forward with an investigation. And, the allegations really helped us in that investigation because it actually called out certain individuals. So we were able to talk with some of the individuals that were named in the allegation. We were able to take a close look at their expenses. And because of what we saw there, we decided to look at sort of the group around them. There were some allegations around others within that division. And because of what we found within the division, it actually grew and expanded a second time. And a larger number of employees were reviewed. And I think this is a great example of, a particular matter where the allegation, or at least one of several allegations, was, perhaps one that, many times companies, look at and say, someone's complaining about someone else's expenses. No big deal, probably small dollar amounts, not really a problem. But when we actually took a close look at the details, and for this particular engagement, we used technology to our advantage. We were able to, our client put together dashboards that were, extremely helpful, identified all sorts of different issues that helped us expand the work that we were doing. So again, a great example of where a whistleblower hotline, started what at this particular client will be, real change, real cultural change within the division where there was a mischaracterization of expenses and some real messy accounting around expenses and approval processes. And again, with the EU directive in that particular region of the world, it's going to allow people to feel a little bit better about coming forward. And with the right tools in place, we'll be able to leverage whistleblower hotlines to help, better their organizations. And so with that, maybe Keith, I'll hand it back to you. We've got a couple of questions I know teed up, and maybe, the first, we talked about this a little bit, and I know you've got experience with this with some of our clients. What steps would you typically take to, say, disguise the true nature of an investigation you conduct? So you're starting out, you're kind of working through the allegation, trying to understand the facts. How would you move forward so that you're not, say, scaring individuals, raising red flags that don't need to be raised? How would you take those first steps?
Thanks, Fred. Yeah, so we see this all the time. We can, of course, be more transparent with those individuals who do know the true reason behind our work. Those individuals are usually from legal. or compliance. But for those interviews with individuals who are not in the know, we have a few strategies that we use to not reveal the true nature of our work, but still obtain the information we need. For example, I recently had an investigation where it was alleged that an employee improperly awarded his own outside company a contract with our client. And I interviewed someone from procurement who was not aware of our investigation. I needed to know how the procurement process worked to see if this individual potentially circumvented the way it's supposed to go. So I started off the conversation with this individual from procurement by explaining that our team was there to evaluate the internal control environment related to a variety of functions, and procurement was one of the in-scope areas. So this allowed me to have a detailed conversation about the various procurement spend thresholds, the reviews and approvals, and all doing so without compromising the sensitivity of our work. Sometimes we go under the guise of an audit or, like I said, an internal controls assessment, but it really is kind of a balancing act, because you want to be able to get to the important information, but you obviously don't want to compromise the confidentiality and the sensitivity of what you're really there to look at. So great question. Marco, is there anything from your side that you wanted to respond to?
Yes, I know we're getting close to time here. There have been a number of good questions. Maybe quickly, one from the audience, switching gears back to the EU Whistleblower Directive. The question is, what about countries which do not allow anonymous reporting, for example, Spain? That's a great question, and the answer is that the EU Whistleblower Directive is designed really to kind of put a level playing field and to put some standards within the European Union, because of the correct fact that different countries have different regulations: Portugal, Spain, Sweden. So essentially what will happen with the EU Whistleblower Directive going into effect, that it is to be assumed, and it will be the case, that the requirements under the directive, also with regards to the protection of the anonymity and allowing anonymous reports, will be possible even in regions where it currently may not be possible. So that's really one of the reasons why the EU has implemented this directive, is to get to a certain standard across the EU. So anything that has been in place is to be expected to be kind of overruled by the new requirements. There's another good question here, specific incidents. What about applicability for US subsidiaries of EU-based parent companies? It's a great question, and of course it will happen in many instances. What I will say is that due to the fact that anyone, including third parties, are covered by the directive, even U.S. subsidiaries who may or may not have a parent company in the EU, European Union, they will be affected by the directive, because the protections will cover anyone they do business with who may be located in Europe. And it's to be expected that if you have a European-based parent company, you very likely will do business with other European companies. So because of that, yes, the directive will also cover this specific case. So we are up on time. I want to conclude the Q&A and really thank all of you for your participation today. We hope you enjoyed the webinar. We were delighted we were able to share some feedback. I hope there were some good learnings. If you would be able to complete the survey, we would really appreciate it, as we always look to improve our programming. And one of the final things I want to make you aware of is our EQS compliance knowledge hub that is available on our website to you. And yeah, finally, thank you very much also to you, Fred and Keith. Really was a pleasure. And any closing remarks from your end?
Marco, no, just thank you for having us today, and we appreciate the opportunity to be here with you. And our contact information's out there. If there are any other follow-up questions, we're happy to take a call or an email. Thank you.
Thank you, Fred. No, really appreciate it. And we will follow up on all the other unanswered questions. Goodbye to everyone, and I look forward to welcoming you on one of our next sessions. Bye-bye.